country's policies and governance of the GDPR and be able to put its principles into practice. We all have personal data and have to share it with other parties on many occasions. This can be as simplistic as giving your name and address to a food delivery app, or providing detailed financial details to a tax inspector for an audit. However, problems can arise if this data is used for purposes other than what the owner consents to. Examples of this could result in infringements such as unauthorized information sharing, leading to significant crimes such as identity theft or even threatening national security. Even if it doesn't relate directly to a business or a job role, each element of personal data can become an identifier, which could be used to gain access to confidential information or perform otherwise restricted activities. The UK's GDPR recognises the risk that identifiers may have when it comes to storing or sharing personal details and considers it necessary to install safeguards for them on most occasions. Examples of an identifier will be any offered material that could be unique or distinctive in nature, such as full name and home address, organisational identification numbers, location data or IP addresses, online passwords or user logins. It's important that any working system uses identifiers in the proper way and with the consent of the owner. People can be selected for processing or engagement through algorithms that might compare things such as localities or shopping preferences, in which case a name or age would not be a significant identifier as such. The main purpose of the GDPR is that it offers a foundational legal framework to keep all aspects of everyone's personal data safe from misuse. It does this by ensuring that the organisations have robust processes in place for handling and storing information that has been gathered for necessary operations. To comply with GDPR protocols, a company must consider the impact and reasoning for collecting data, which can be affected by many variables. It should also look at whether the data collected is truly personal or unique to that individual before it is shared or processed in any significant way. The three main factors to look at are content of the data. Is it directly related to the individual or their activities? Primary purposes for gathering the data. Outcomes and consequences that the data owner will experience once it has been fully processed. As a result of all of these variables and factors, it can be challenging to define when data can be personal, confidential, or sensitive in nature. Because of this, all gathered information must be treated with care, and there must be clear objectives for any processing. In addition to this, data must be safeguarded to an appropriate level, along with adequate strategies for storage and reliable disposal procedures. For clarification, the UK GDPR refers to those who manage data as being controllers or processors. Someone who works in this area will be able to differentiate their role with the following definitions. Controllers. These are the main decision makers. As regards information management, they exert overall control over the reasons for collecting data and how it is processed. It is possible for two parties to operate as joint controllers. Processors. These are parties acting on behalf of their relevant controller and will obey the instructions that they are given regarding the data passed to them. However, they also must ensure that the data remains safeguarded during their operations. Within the GDPR framework, controllers have the highest level of accountability when using gathered personal data. They must be seen to comply with all elements of the regulation and any requirements associated with it. In addition to this, they must ensure that their appointed processors also comply with all appropriate legislation. In most circumstances, controllers will also be liable to pay a data protection fee and could be subject to court proceedings if they fail to protect data or willfully misuse it. With all this in mind, the governance of UK GDPR works in the following way and directly applies to the following parties. It relates to all data controllers and processors in UK territories. It pertains to any data processing carried out by organisations based in the UK. It refers to the operations of organisations located overseas, expressly in the processing of goods or services supplied to individuals in the UK. It does not cover the processing that may be required by law enforcement directives, particularly where it may apply to national security issues or criminal activity. It may not cover processing solely carried out by private individuals for personal objectives that do not include commercial purposes. At its heart, the GDPR has a set of very basic principles that provide the groundwork for all of its protocols and guidelines. They are not black and white directives or commandments that must be obeyed to the very letter. However, they do represent the spirit of effective and ethical general data protection strategies that should belong in all working organisations and businesses. By complying with these core principles, your company is not only obeying the law, but also showing respect for your customers, clients, and community. The core principles of GDPR can be summarised into 6 ideologies, which are elaborated upon in UK government legislation. These are: personal data should be processed in a manner that is lawful, fair and transparent. Personal data should only be collected for specified, explicit and legitimate purposes. Personal data collection should be limited to what is necessary in relation to intended purposes. Personal data should be accurate and updated wherever necessary. Personal data should be stored for no longer than is absolutely necessary. Personal data should be safeguarded against unauthorized use, criminal activity, and accidental loss. In terms of definitions, fairness and transparency may seem more open to interpretation than lawfulness and other elements of the GDPR. However, it ensures that deception and false claims are not used to solicit requests for personal data, and that the reason for gathering the details is made clear at the very beginning by data collectors. Failing to ensure this is the case means that a collector or company could be legally prosecuted, fined proportionally, and suffer severe reputational damage. By ensuring that companies obey in a lawful manner, the GDPR is in place to protect all individuals from the criminal or malicious use of their personal details. The collection or processing of the private data will be considered illegal if it directly contributes to or enables the following activities: breaches of professional duty or confidence, organisations exceeding their legal authority or abusing their powers, copyright infringements, breaches of contracts or legally binding agreements, breaches of industry laws and regulations, violations of the UK's Human Rights Act 1998. Whenever personal data is being gathered or requested, the collector must be very clear as to the reason for this. They must also ensure that the participant knows their rights regarding the procedure and that only the required information is taken. Taking additional and unneeded details could increase the risk of unlawful access, as well as add extra complications to security and storage. Following this protocol will help maintain accuracy and integrity whilst limiting the amount of data that will have to be referenced in any searches or processing. The other considerations that companies, businesses, and data collectors will need to be aware of in order to comply with GDPR legislation include the following: ensuring the validity and accuracy of all personal data where it is reasonably possible, keeping records of changes or mistakes noted in gathered data, deleting or destroying expired data in the appropriate manner, providing adequate storage and retrieval methods for personal data, taking accountability for any internal breaches or misuse of collected data. That completes the first lesson of this course, where we have covered the basic principles and purpose of the UK version of the GDPR. The importance of fairness at every stage of data collection can be seen as a core value, as are other factors such as accuracy, security and efficiency. Please stay with us for the next lesson, where we will examine the legal foundations of the GDPR in much greater detail and the inherent rights that all data owners have. See you shortly.